When you say restrictive covenants, you're typically talking about a non-competition clause or a non-solicitation clause. The answer is that yes, in Florida they do recognize restrictive covenants. There are rules around reasonableness. So for example, if it's under 2 years, it might be reasonable. Depending on the circumstances, you have to have reasonableness in terms of the geographical scope. So if your primary business operations are in and around Hillsborough County, Florida, and you're trying to keep somebody from working anywhere in the state of Florida, that is very likely to be considered too broad of a geographical limitation. Now, if you're an internet-based company and all of your business is online, that geographical scope could be much broader and still be reasonable. If you're too broad in terms of restricting someone's behavior, whether it's an employee or a contractor or something else, the courts in Florida are allowed to kind of whittle that back and make it more narrow in order to be in compliance with Florida law. That's somewhat unique to the state of Florida. Not every state does that. So the best thing is to make sure that you have a reasonable restrictions in your contract in the first place, I would say, as opposed to making them super broad and have to deal with the judge being irritated with you, and maybe they'll whittle it down to where you want, and maybe they won't. So understand what it should say, and it generally is enforceable in Florida.